Hello viewers, in this lecture I'll talk about void agreements which are specified in section 26 to 30. But before we go to that, I would request you to recall what I have earlier said about what is void. Section 2G. Section 2G says, agreement not enforceable by law is said to be void. Again, try to recapitulate what section 10 says. Section 10 says, all agreements are contracts if they are made so and so, so and so. And the last line is, and are not hereby expressly declared to be void. Put stress on this line. Hereby not declared to be void. Meaning thereby, if the agreement is declared to be void by law, mind well, even if all other elements are present, the agreement would still be void simply because of the fact that it is so declared by law. In fact, there are so many laws which declare particular transactions as void, either because they are fraudulent or when law wants to implement some policy, say agrarian laws, land laws, where the land was to be transformed from landlords, zamindars. Law has declared certain transactions as void. In that situation, definitely such contract cannot exist. But section 26 to 30 are the sections which, irrespective of the considerations, law says that specified agreements are void. Meaning thereby, even if all elements are present, law shuts its eyes on such transactions because they are not existing in the eyes of law as being void. First such transaction is with regard to marriage. And section 26 says, the caption is, agreement in restraint of marriage is void. I would read the section and then proceed further. All agreements in restraint of marriage except minor are hereby declared void. Pausing here for a moment. Again, this is different than marriage brokerage agreements which I have referred to under the caption of public policy. This is about specific restraint. Though the philosophy remains the same, that marriage is the culmination of willingness of two adults. In marriage brokerage, the intent is to procure marriage. Here, if the effect of agreement is restraining someone from marrying, law says it would be void. In short, you can never say anyone that you shall not marry till the happening of this event. or you shall not marry till you complete your age of 25. But yes, as the saying goes well, every rule has an exception. Here also there is an exception, and that is with regard to minor. And the reason is obvious. Minor cannot marry. And therefore, if you put a restriction during minority that you shall not marry, it is valid. So, agreement in restraint of marriage means any aspect, any restriction which has the effect of restraining the person from marrying with person of one's choice. The exception being only minor. The next section is section 27. Section 27 says agreement in restraint of trade or profession are void. I'll read first the section and then we'll proceed. Now look here. This law is made in 1872. Our constitution came into force, obviously need not be told, 26th January 1950. And Charter on Human Rights is also of 1948, which recognize right to carry on any trade, business or profession as a human right, as a fundamental right. But this law way back in 1872 not only recognized this, is made effective by making a provision in section 27 that you cannot prevent anyone from carrying on any trade, business or profession which is lawful. Obviously, we don't talk of illegal things. Therefore, any stipulation in the agreement which has the effect of restricting one from carrying on any lawful business, trade or profession, law says, is void. This also has an exception, and the exception is again very well known. Most common examples in partnership, and therefore the Partnership Act specifically incorporates the same. Firm can put restrictions on outgoing partners to the effect that he shall not carry on similar business in a particular area during a particular time. Even while he is a partner, he cannot carry on similar business or any other business. In short, sale of goodwill, yes, at that time the restrictions can be made even when the entire business is sold. Here I would like to make one point clear, that often you will come across that during your employment tenure you are prohibited from doing any other activity. Would it not come in conflict with this provision? The answer is yes. Then how is it that it is valid? Mind well, there are two different types: contract of service and two, contract for service. What section 27 says is for contract for service. What is contract of service? The simple example is employment contract, where you undertake to serve someone for a periodical remuneration. And obviously it is the right of the employer to prevent you from carrying on any other activity which would have the effect on your efficiency in his employment. And obviously no sane man would accept this situation. And therefore law has also accepted the situation that yes, section 27 applies for contract for services and not for contract of services. Barring this situation, let us be very clear that there cannot be any stipulation in any contract which has the effect of restraining anyone from carrying on any lawful trade, business or his profession. Profession would not be a matter of much importance here, because profession can be carried on only on acquisition of required qualifications prescribed by the professional bodies. And hardly such situations may arise. But then also you may come across situation well qualified persons accepting the employment, and the employer again putting the same restriction that you shall not carry on any other activity. Yes, in that situation, that stipulation is valid. The third situation, section 28, agreement in restraint of legal proceedings. I will first read the section and then proceed. This section in substance says that all agreements which has the effect of restraining someone from going to the court initiating legal proceedings are void. Your fundamental right to get justice. And here I would like to make a reference to Article 32 of our Constitution, though you may not be a student of the Constitution of India. But just one line is sufficient for your information. That Article 32 of the Constitution of India says that it is the fundamental right to approach the Supreme Court in case of violation of fundamental rights by the state, and in turn it is the duty of the Supreme Court to protect the fundamental rights. I am making reference of this here simply because to emphasize the importance of one's right to approach court for redressal of his grievance. No one under the sky can prevent you from going to the court. This also is again different than what I have said you under the public policy, because there it is champerty and maintenance. Here it is about the right to move the court. And the right to move the court is, as prescribed by law, is absolute. By whatsoever nature of agreement, one cannot take it away, nor even one can reduce the nature of right. I would just give you one example. If law gives you right to move the court against the wrong within a period of 3 years, the stipulation between the parties provide that if you do not initiate legal proceedings within 1 year, you shall not claim thereafter. This term clearly reduces the time given by law to the citizen for redressal of his grievance. That is 3 years. Now by agreement you cannot reduce it to 1 year. And any such stipulation, law says, would be void. So one thing is very clear: under no circumstances one can prevent the other from going to the court. Even if that agreement has a stipulation of not going to the court, court will not recognize that, and court will proceed as if there is no such stipulation. I would simply give one illustration on this. Friends, I am slow in giving illustration for the simple reason that it is statutory experience. I would even also make a reference to the Evidence Act, which has given illustration in the statute itself, and the side effect of it has been that often people understand the illustrations as law. And having experienced this, even the law has also stopped giving illustrations frequently. Now, look at the service agreement. The service agreement provides that in case of dismissal from service, you shall not go to court. The service of the employee is brought to an end. He goes to the court. The employer appears in the court and takes a defense that, look here, sir, there is an agreement between the parties. The employee has agreed not to approach the court. Court may see it, but will not accept it. And court, despite this stipulation in the agreement, will put aside this term and proceed with the litigation. One more exception again in this is arbitration. Essentially, arbitration is taking away the jurisdiction of the regular courts. In that sense, it is restraining one from approaching the court. But there is separate act which has recognized arbitration as a valid mode of resolution of disputes. And that is the only mode recognized by law. And since it is recognized by law, though in strict some terms it may be restraining one from going to the court, it is a valid agreement. In the next lecture, we'll see about other void agreements. Thank you.